Are you making a mistake on how your property is titled in Florida? Well, that's what this video is about. I'm going to dive in to talk about different ways to title your property to protect you, to avoid probate, to protect your heirs, right? That's what we're talking about. Stick around. Hi, welcome back. My name's Joe Brown. I'm a real estate agent with Century 21 List with Beggins, located in South Tampa. Thank you so much for being here with me today. So I've been doing a lot of research lately and looking at property records online, and how they're titled is all over the place. And I see some of the ways they're titled really may not be the best. And so I thought, this is an important topic that I want to share with you. And please, please, please share this with other people that you think need to hear this. Okay. So let me just, quick information, right? This is important. How you title your property, talking about residential property, how you title it is important because it's a matter of protection for you. It's a matter of protection for your heirs. There are tax consequences. There's inheritance consequences. So please, if you need to watch this video again and again, and I'm going to share some notes in the show notes. So please check out the show notes, download the file. Hopefully that'll help explain or help you understand some of these concepts, okay? And before I get to title, let's talk about taxes, because this is an important concept, an important component to property. So let's say I buy Amazon. I buy 1,000 shares of Amazon when it was $5 a share. So I spent $5,000 on it, right? $5 a share, bought 1,000 shares. Well, right now, Amazon, let's say it's $1,500 a share, and I own 1,000 shares. Well, now that's worth $1.5 million. Well, if I sell those shares, I'm going to have huge capital gains. However, if I die, those shares go to my heirs and they receive what's called the step-up value. So the basis of their shares are the price of Amazon when they inherited it. And then the only capital gains they would have is from when they sold it to when they inherited at $1,500, right? So step-up value, that's an important point you need to understand. Step-up value. So now let's talk about how you title. Excuse me, I'm moving all around. So let's talk about how you title property. And it depends, first of all, who owns the property. So me, Joe Brown, I go buy a house. I'm all by myself. You know what? I put it in my name. I put it Joe Brown. So property records, you'd search, Joe Brown owns this house. Okay, but very simple. I own it entirely. I can sell it. I can pass it to my kids through probate. I'll talk about that in a second, right? So it's just sole ownership, sole proprietorship. But let's say my buddy Mike and I buy a house together. And we set it up that I own half the house and Mike owns half the house. Now listen, tenants in common, it can be 90-10, 75-25. It depends, right? In this example, I own half the house, Mike owns half the house. But then Mike decides to take a trip to Costa Rica and needs money for this trip. So Mike decides to sell his half of the house to Rob. Do I get a say? No. Do I know Rob? Maybe not. Do I like Rob? Doesn't matter. Mike has the right to sell his half of the house to Rob. But let's say Mike doesn't sell the house. Okay? So the house is still owned by Joe and Mike, 50-50. Mike goes to Costa Rica, zip-lining 45 seconds and dies. I know, pretty gruesome, right? Anyway, Mike dies while zip-lining. What happens to his house, his half of the house? Well, it goes to his heirs, whoever his heirs are, right? It goes through probate. Even if it has a will, it goes through probate. Who is this good for? Well, this tenants in common would be, number one, just two individuals buying a house together, right? And they want equal shares of the house. It could also be for married couples who have children from previous marriages, and they want to protect the inheritance for their kids from the previous marriage. Okay? That very, right? Because in this case, Mike dies while ziplining. His half of the house would go to his heirs. So that's a way for married couples who have children from previous relationships to protect their children, tenants in common. Now, there's also something called joint tenants with right of survivorship. Sometimes you'll see it JTWROS, joint tenants with right of survivorship. So in this case, Mike's in Costa Rica ziplining. He dies. His half of the house comes to me. Okay? Now, there's a tax consequence to that, in that Mike and I aren't married. That's a good thing. I like Mike, but not that much, right? We're not married. So his half of the house coming to me is, quote unquote, a gift. And there is a gift tax. Okay? Understand that. Now, I don't know. You have to talk to a tax advisor, tax accountant that knows what are the limits for gifts and tax consequences, all that, right? I don't know. I just know the right of survivorship of an unmarried couple constitutes a gift which triggers a tax consequence. Well, let's change it now. It's a married couple, right? So in my case, Rosemary and I, we own this house. It's in our name. I go ziplining with Mike and I die as well. Well, then whatever ownership I have the house automatically goes to Rosemary, and it's not a gift. Okay? It's not a gift. So that is right of survivorship. Now, let me go back. I talked about the married couple who have kids from previous relationships, right? Well, so let's take the scenario that the husband dies and it's right of survivorship, so the share of the house goes to the surviving spouse. Well, you know, sometimes families get into arguments because the stepmother doesn't like the stepkids, or stepfather doesn't like the stepkids, and how are they going to divide the property, right? So that's why, going back, the tenants in common, you can protect your heirs. If those aren't issues, then you can do the joint tenants with right of survivorship. So the full share goes to the surviving spouse. Now, all of those ways go through probate. And I did a video months and months and months ago about what happens when you die. And I'll put a link to that video at the end of this video because it's worth watching. But if you die, it's just not clean, right? you have to go to court, and the court has to designate a personal representative. And you have to put notices to creditors, and it has to be a 90-day waiting period. And then we can transfer ownership or sell the house or whatever. And there are costs to that at the very minimum, right? So now this is based on my search, right? For a small estate, you're looking at about $2,500 to go through probate. If you get to these larger estates, it can be $20,000, $25,000 or more, right? So there's going to be costs associated with the probate process. Well, how do you avoid probate? Well, and I talked about this on my video. It is a clean way to do it is a trust. So Rosemary and I have the trust. Our house is in the name of the trust. And the trust designates, if I pass away, everything goes to Rosemary. When Rosemary passed away, everything goes to the kids. It's in the trust. It's set up. The trust avoids probate, right? And it is just a clean move. Now, and I've seen this quite a bit. How about those families that have kids and they don't want to do the trust? They just want the house to go to their kids. So they say, you know what? We'll just put the kids on the deed. I see that quite a bit, right? So it would be Mike and Kim and Reagan and McKinley all on the trust. Well, let's go back to step up, right? So the example I used, I bought shares of Amazon at $5. It's now $1,500. So for a house, if you bought a house 35 years ago for $50,000, that house is now $600,000, but your kids are on the trust, their cost basis is $50,000 because they're on the title. And so if you pass away and they go to sell the house, they're going to have the capital gains from $50,000 to whatever it sells for. So there's a workaround, and it's called, I want to get this right, the enhanced life estate. It's also called the ladybird deed. Okay, and this is very common, ladybird deed. So ladybird deed says, when I die, the title will automatically be transferred to my daughters. That's the ladybird deed. Up until I die, I own the house. I can buy it. I can sell it. I can clean it. I own the house. But when I die, it transfers automatically to who I designate in the ladybird deed. That's a very clean way to do that. And because of the ladybird deed, my heirs, whoever I designate, gets the step-up value. It's not a gift, so there's no gift tax, and they get the step-up value. Okay? Now, I was talking to, well, a couple different ways to title is through an LLC. So an LLC is just a limited liability company. And I see this quite a bit, right? House across the street, maybe 4741 Taccoon Street, LLC. Well, it's owned by somebody, but the title of the house is in the LLC. That's fine to do. There may be reason to do it for residential property. Absolutely talk to your legal advisor and your attorney about that. But I have seen that done where the titles are in the LLC. I was talking to a gentleman just the other day who was former military. And he said, I really wish there was a way for more privacy in title. Well, there's something called land trust. And the land trust, it doesn't name the owner as the owner of the property. It names the trustee. So if you search public records, you'll never find Joe Brown's name. You'll find the name of the trustee. Even though Joe Brown may own the trust, the land trust, and he owns the house and operates the house, right? So there's a level of privacy. Now, is it foolproof? Yeah, probably not. But there is a layer of security. Somebody would really have to dig and know how to dig to get that information. So there are land trusts. But let me tell you, whether it's the land trust, the living trust, the ladybird deed, even if you just want to add your children to the title, all of that is going to require work of an attorney. Because you could call the title company, and the title company is going to say, get an attorney. Because one thing about attorneys, they don't want non-attorneys practicing law, right? And in fact, there's state law that says realtors, real estate agents, cannot practice law. Title companies cannot practice law unless they're a lawyer. So absolutely you have to work with a lawyer. That's why I go back to the cost of probate. At the minimum, probate is going to be about $2,500 to go through probate. You can set up a trust, a living trust, for about $1,500, and you avoid probate, and you set everything up of where the money goes and the heirs and everything, right? The tax consequences. So that is, listen, if you want recommendations for estate lawyers, you can reach out to me. The gentleman I use actually retired, but look for an estate attorney, that they're your best bet. Vet them to make sure they know what they're doing, right? As I mentioned before, check the show notes below. I will have a graph showing these different ways to title property and what some of the implications are. Reach out to me. Go to my website, joebrownc21.com. You can read my blogs. You can search for homes. And listen, if you think I can help you, please reach out to me. If you listen, I have a lot of subscribers. Thank you so much. If you haven't subscribed, just please hit the subscribe, leave a comment. I appreciate that. Listen, buying a house is good, right? It's a good thing. Having it titled properly is even better. Until next week, take care.